Beautiful friends. What an amazing day it is. Welcome back. Great to see you again. We were here this morning talking all sorts of Epstein nonsense, really. And so we unpacked all of that earlier, just a few hours ago. But we're back with fresh, new business to attend to. And so quick preview before we zoom in on further detail. For further detail, we've got Lisa Cook is a little bit shook in the House, and I'm patting myself on the back for that one. She has now submitted a reply. She's trying to get Trump to put her back in power and is duking it out in front of her sorority sister judge, Judge Gia Cobb, battling this out, and we're going to see where it goes. But what they're saying here from this attorney, Abby Lowell, is that she's going to be getting stigmatized and reputational damage. And so, as we know, when you start going down that route, right, it's irreparable injury, and is what she says. And we go, come on, you sound pathetic. So we'll go through this and see what she says, and then get some response and reaction from the man who started all this, Bill Pulte, because he's also out, and he is saying, look, we're going to continue to move forward on this. And quite frankly, where is the Federal Reserve Chairman, Jerome Powell? Why has he not disavowed this woman? Or what's the status? Like, does she still have access to her emails? Is she still in there not lowering interest rates? What's going on? So we'll see what Bill Pulte has to say all in the first segment. Then we've got more business because we've got this amazing dissent you see here that was drafted by the Fifth Circuit judge called Andrew Oldham. And this is a dissent. Trump just lost this. It was a 2-1 decision saying that he can't do what he's doing to the Tren de Aragua gangbangers. And this, I think, will go up on appeal, but this was a beautiful dissent. And Trump obviously will take this to the Supreme Court or to the full panel, and we'll see what they say. But this dissent was epic. And he goes through the lineage, and he says, something is very interesting here. For Trump, today, the rules are different. And he walks us through this long history. We'll fast forward through a lot of it, but how all the other presidents used this power until Trump came in, and all of a sudden, an entirely different set of rules apply to him because we're living in a corrupted environment. So we'll talk about that. Lots of reaction to President Trump announced that they took out some of these TDA terrorists who are trying to invade our country with drugs that actually kill Americans. Hundreds of thousands of Americans, if not millions, are dead because of this crap, and we're tired of it. So Trump took them out, and a lot of reaction to that. Liberals all over the place. This is a war crime. How dare you? And of course, they never screamed any of that when Barack Obama took out an American citizen who was overseas without any due process. Remember that? So Rubio's out. We've got President Trump, J.D. Vance are both out, all talking about the obliteration of the terrorists, and we'll get into it. So we've got 2 segments today, my friends, and we're very excited to get into it with you. Thank you for subscribing to our channel if you haven't already done that. And Membos, stick around. We're going to do an after party and say what's up at the end of the stream. We appreciate you being a Membos. Thanks for being here and supporting our work. Couldn't do it without you. So now we've got some business to attend to. And let's start with the Lisa Cook case right up at the top, because she seems a little bit nervous. Lisa Cook is looking shook. She submitted this motion here in a reply to President Trump's firing, essentially, of her, saying you're removed from this position unless you resign. She didn't resign, and she needed to go. She didn't explain herself in any way, shape, or form, still hasn't to this day, about why her mortgages all say primary residence in multiple locations, and she got them back to back, and then suddenly is just being mum about it. And we got questions about her propriety and her integrity, and she's refusing to answer it because I guess she's better than us. But this is her reply in support of her motion for a temporary restraining order. Now, she wants President Trump to be stopped from the firing, and she submitted this. And we'll go through it. Now, I think you're going to see a little bit of panic in the voice when we get down to this section. Page 25 says, given the unique role of her, removal without these proper procedures would cause her irreparable harm. What is that irreparable harm going to be? Stigma and reputational damage. That's the irreparable harm. Well, anybody who gets fired for things is going to have a little bit of a stigma and reputational damage. And that was only compounded if you were the person who committed fraud. And that was the justification and the cause for your firing. And so we'll get into that, but they're going to go through and you're going to see this feels like they're stretching big time. And we're excited about this case because this is like the final boss, final level. This is the Federal Reserve, all right? Of all the independent agencies that exist, this is like the big one, all right? Nobody wants to touch it. Supreme Court has carved out a bunch of exceptions for this illegal entity. We never, ever should have an independent, non-governed pseudo branch of our government that has such massive power, or any power. They all live under the executive branch. Unless they want to amend the Constitution, they didn't do that. So this will matriculate, hopefully, into this battle. And maybe the Supreme Court once and for all will come out and say, yes, there is one executive branch in this country. And if you're going to try to create all these little pseudo branches under it, that's illegal. And so here is what Lisa Cook had to say. She submitted this. We'll fast forward through the table of contents. And she says, the government, Trump, as it must, they agree with us that the president's removal power is limited to for cause, right? And we've been battling over this word. What does for cause, this phrase, mean? What is the definition of cause specifically? And does it cover anything Trump wants? They want the standard to be very tight and narrow, okay? So that for cause means you have to be convicted of a felony and have exhausted all your appeals to the Supreme Court. And only then is that cause and you can be fired, right? Same type of garbage we see with the illegal aliens. They say same thing about them. Well, you can't deport them. Well, they're here illegally. Well, but they haven't killed anyone. Like, well, that's not the standard, weird people. Same here. It says for cause. And we've already read through Trump's response to this request for a TRO, where he explained it very clearly. And so she says, it doesn't mean that he can, fire me, essentially. Now, similarly at odds, she writes, the government would reduce the right to a notice and hearing. Okay, so now she's acting like she has been charged with a crime. You get charged with a crime, you got to get notice of that. You can't be prosecuted if you have no notice of something and you just show up like, oh, you got convicted of, you're guilty of murder. What? I didn't even know. That's not due process. But she is not being charged, not yet. And if she does, Pam Bondi's got the criminal referral hopefully sitting on her desk, not next to the Epstein files, in a safe place, then she can file and make her complaints in other districts. She can go over to the Court of Federal Claims. Trump responded in his reply saying, I've got cause. If you don't like my firing, if you think that she was damaged, she can go file those claims. We talked about this yesterday. There's a whole litany of these cases. And it is the same argument. It's the same challenge to the power. They say that we can create these independent bodies. We say no. And she's not been charged with a crime. And so why is she entitled to notice and a hearing to determine if she was lawfully fired when the law says very clearly that the president can do so for cause? He can fire you for cause. And the law is very expansive in those powers. And says, when asked about this, Trump was saying, yeah, I can fire you. Now, she's going to go through and we'll fast forward through a lot of this. She says, okay, the government is referencing this case, the Reagan case, which says that the president's decision to remove somebody is unreviewable. But they say, well, let's look at the text. And she's going to go through some analysis to try to, make the words much broader. And so we'll fast forward through a lot of this because a lot of it's just kind of, law, which is pretty boring. Here we go. The government's argument that Trump and his decision to remove a board governor for cause, they say it's unreviewable. Well, that cannot be squared with what happened in Trump versus Wilcox. The Federal Reserve's independence would come to a screeching halt if you allow this to happen, and the president would be handed blanket permission to unravel the foundations, look at this, of a unique institution with a unique historical background. Is there a unique institution or historical background clause in our Constitution anywhere? It says, well, you can create fake executive agencies as long as they're unique with a nice historical background. What the heck is that? It's a special arrangement sanctioned by history. Okay, it's like platitudes. And that was from Alito, who is dissenting in a different decision. So in enacting the Bank Act, and this is my point on this, like this is why this case is so big. It's like, what is that what Alito meant? Did he mean that the Federal Reserve is going to stick around forever? Because I don't think that's his prerogative. I think that Alito understands the Constitution. We'll see where this goes. But he was in the dissent in that case, whatever they're citing. So they say Congress wanted, this is wild, because if Congress intended this, like literally, they could have written it in there, and they didn't do it. They didn't say for cause only if you're convicted of a crime, or for cause if there's a preponderance of the evidence standard and you have a notice and hearing. It's not what the law is. It's for cause. It's the president. You can't shackle the president. Otherwise, the person who's shackling the president has more power. Okay? And that is constitutionally illiterate. That's not how our system works. In enacting the Banking Act, they say Congress expressly rejected proposals that would have granted the president complete control over the Federal Reserve Board membership. Okay, so that is not even a relevant parallel. Trump's not trying to exercise total control over the Federal Reserve. And so they're introducing debates from the original passage. And they're saying, well, some people will, and during the debates, doesn't matter. The law says for cause. Thanks for your argument. Now, as the court standard in Humphrey's Executor, which hopefully gets overturned by the Supreme Court, this is what we're talking about. They said in Humphrey's that we really should interpret for cause, the Supreme Court says, only for inefficiency, neglect of duty, or malfeasance in office. And when we talked about this previously, we said you could check the box for any of those things as it applies to Lisa Cook. Inefficiency, neglect of duty, she should have reported her, on both counts, reported this. Hey, I've got this thing that might be a problem. She didn't disclose it to the Senate during her testimony. And malfeasance in office, she was paying the mortgages. These fraudulent mortgages, I presume every month. So is that not a perpetuation of the fraud in office? And if you say, well, maybe it hasn't been proven and there is no actual impropriety, let's just say she's just dumb, even though there's no evidence of that because she went to all these really elite schools and was teaching there and all sorts of stuff. So malfeasance in office, maybe it's just dumb. I'm just, I have no idea what I'm doing. I can't read paperwork, which is a problem. Then she shouldn't be in the Federal Reserve. But that's malfeasance. You are in your position of power, supposedly supposed to have no appearances of impropriety. Doesn't matter if it's actual impropriety. It's appearances of impropriety that also count. Now, they're going to say the Supreme Court has suggested that for cause and other things are synonymous. Then there was some amendments, and the Supreme Court recently made clear, now we get to some new stuff, that any for cause safeguards the agency, independence must apply with particular force to the Federal Reserve. And I don't think they really said that. They did make a note, okay, because in this Trump versus Wilcox case, I think this is not really accurate. It's kind of dishonest, which is not a surprise coming from Abby Lowell. But they didn't actually say that per se. Remember, Trump versus Wilcox, Trump fired somebody else, and the Supreme Court said, you can do that because you're the president, And the argument back was like, well, we have all of these other entities that are independent executive agencies, essentially. We've got the Merit Service Protection Board or the Office of the Inspector General. They fired Dellinger. They fired Wilcox. They fired, all these different people. So they said, well, if you can fire us, then they're going to come after your sacred Federal Reserve. That was their concern. And they were filing that in these cases, Trump versus Wilcox. You can't do this, Supreme Court. Think about the compounding effect. It's just going to trickle down to all of the other agencies and they're all going to get nuked. Yeah, we know. The court in Trump permitted removals of the National Labor Relations Board. Remember, because this National Labor Relations Board was set up to be insulated against the executive branch in America. And that was unlawful. And the courts came and said, yeah, sorry, they can go. So in 1972, the Federal Reserve General Counsel said some nonsense. And the Supreme Court in 2021 also stated that the for cause removal restriction for the FHFA director appears to give the president more removal authority than statutes specifying particular bases for removal. But the court had no occasion to definitively interpret any of this. And so now here we are. Now, the government is saying that they can come up with any articulable justification that the president deems sufficient, except for mere policy disagreements. Yeah, it's called cause. If the president has cause, he's the president. And if you don't like that, well, then you can sue as you're doing. You can go into the other courts that have been set up for your firing complaints. Congress can be saying, this is outrageous. Trump is breaching his obligation to take care of the country and execute the laws. And they can impeach him or do something like that. But what we don't want is Congress to delegate their responsibility. Okay, if they don't like what the president is doing, their check and balance is impeachment. They don't get to be big babies and just divest themselves of the responsibility and give it over to independent agencies that are insulated from any political accountability, because that's their job. And so mere policy disagreements is not even being debated here. But if you have cause and a policy disagreement, that's the president's prerogative. Okay, it's one executive agency. Congress can't outsource this stuff to third parties. And that's been happening for decades, since 1913. This position leads to an absurd conclusion, they say, that the president has dramatically more power to remove people from the Federal Reserve. And I don't think that's the argument. It's the same power. It's the presidential power across the board. Remember CELA law, we covered that case. CFBP, we covered that case. And now the government says that cause cannot encompass mere policy disagreements. I would say, I think it could. I mean, whatever, it doesn't say for cause except for policy disagreements. And again, if Congress wants to change this, just go amend the statute. They're not idiots. They have some power. They can just go change the law. Why don't you just go pass legislation that says, actually, we're going to go amend the statute and say for cause means this. Only if Lisa Cook is convicted of murder, then you can remove her. Congress can change the law. They wrote it, but they don't want to do that, okay, because they're pathetic. They'd rather just outsource this stuff. And we don't want that to happen, because all that does is seed other oligarchical bodies that seize control of our political process without any accountability, and Congress must do better. The government argument only works if they relied upon a dictionary definition. And I think it actually is broader than what even the DOJ is saying. But they say that the prevailing understanding of cause at the time that this was enacted was almost exclusively for conduct undertaken in the course of the office. Okay, so she says, I committed my mortgage fraud before I got the job. What's your problem? Pre-office conduct was generally not grounds for removal. So she could have embezzled $1 billion and there's nothing you can do. It's just, it's her. And wait a minute. Financial improprieties are a big problem for somebody who's on an institution trying to secure our financial propriety. Seems like it's a problem. So they go back, they go through the canonical English case. They go back to 1758 over in England, and we'll fast forward through that. But pre-office conduct is addressed through the vetting process and the impeachment process. All right, so then Congress outsources this stuff, and then you expect Congress to go check the branches, these fake branches that they set up, to check the power that they delegated to them? Okay. And they don't want to make hard decisions. Like, that's a hard decision to make. Well, hey, I'm a Republican, and I think that Trump is firing, this is like a major issue for me, so maybe I will impeach him. And you start, wow, and that creates some pressure, and you have a check and balance and a separation of powers. You don't have this muddled gray area that's disgusting, because the grift exists in the gray. This allows the nominee to address the allegations, which she didn't disclose. Nobody discovered it until now. And so, well, you could have asked me about it, and you didn't. And so I committed fraud, so it doesn't matter, and I got past the post. Now, even if pre-office conduct were considered against the broadest definition of cause, if we expand that out, the allegation on which Trump took his action is not cause, okay? So they're going to address, hopefully, the charges here and explain what happened. The government mistakenly says that Cook's alleged conduct, which is making contradictory representations on financial documents with no explanation given, is cause. Now, even if the president's authority is for cause, as the statute says that Congress wrote, even if it was comprised to a limited set of circumstances, it should be much higher. The standard is clearly not met here. Okay, so again, they're defining cause. Now he's saying cause has to have moral turpitude, or you have to have cause. I mean, if it's convicted, you're convicted of a crime. So give me a break. So the contradictory representations are not moral turpitude. They're not criminal convictions. And when you talk about crimes of moral turpitude, it's generally crimes of dishonesty, fraud, deceit, conversion, all these kind of, concepts where it's not like a crime of passion. You have a self-seeking, dishonest interest in the offense. Instead, they are unsubstantiated, untested, and unaddressed allegations. If such unfounded allegations were cause, the president could fire a board member over mere policy disagreements, which I think he can. I mean, honestly, like, it's the president. There is one executive branch. And the shackles on this position are unconstitutional. So including the timing or an interest rate drop, but as the government concedes, that's not the law. And they're not trying that, they're not trying to, I think, overturn the entire Federal Reserve right now, but not yet. And we've had conversations here about firing Jerome Powell as well. And let's just duke this whole thing out. Hans Mahnke made that tweet. Moreover, the asserted basis for Governor Cook's removal suffers from another legal infirmity. What is this? Well, the government has long known about these facial inconsistencies alleged in her financial documents. At August 29th hearing, the government conceded that if it was something that was known at the time, it's much harder to say that it's caused later because the presumption is that the judgment has already been made. Now, the contradictions were included in documents disclosed to the White House before she was appointed by the president and confirmed by the Senate. In fact, during her confirmation process, she submitted questionnaires and provided reports that would have revealed the same purported facial contradictions the government now claims to cause to fire her. Again, so as long as you get the fraud past the government, you're good. Just get it in there. Senators are idiots. They're not going to criticize you because you're a historic black woman, first one ever on the federal board. No one's going to have, and actually it was a very contested hearing because she's illiterate as an economist. A proper hearing would demonstrate that the government had prior knowledge of these facial contradictions before the president invoked them, Trump, as the basis for her purported removal, and saying, this was known, like you already knew, so you can't now make it up as cause, which I think is just kind of sequentially out of order, right? It logically, if you can just get past the post, then you're good to go, is their standard, essentially. So in May, even if there is an appearance of impropriety later on down the line, where the president has absolute for cause to fire you. So then they come through and they say, well, Trump wants her gone. And right, they go through all Trump's posts. And we often say a lot about this. It's like, if you're representing a client, you don't want them to start running their mouths. Generally not good for your case. But Trump is the president. And so any words that come out of his mouth have a lot of weight, carry a lot of power. And so they seize on them and they say, see, this is evidence of other things. And if Trump didn't make these posts, if he didn't say these things, then they wouldn't be able to write these paragraphs. But, the president, like, it's a little bit, it's a lot of bit different than prior presidents to comment on these things. But it is the president and it's his job, right? This is what he should be doing, is governing and holding people accountable who are not performing well in his administration. So again, the fact that he's making comments on it, I don't think is an excuse to say that she cannot be fired because it has to be for cause. In other words, this is not for cause. This is just a mere policy disagreement. So what? Mere policy disagreements can be cause. What if there is a bad policy decision that's coming out of there that interferes with the president's duty to take care of the country? How do you have accountability for that in this system? You don't. That's the point. The court should accept the government's invitation and look at Trump's own words and evaluate him, because he is just trying to fire her for a pretextual reason. Now, she is going to go on to talk about due process. Again, I know. Due process, it's like the word of the year. Together, these require notice and a hearing when the president wants to remove an official with for-cause removal protections. As Justice Breyer put it, who's irrelevant, the government's attempt to resist the well-settled rule fails, and more. Now, we're going to get to some of the good stuff here. So due process. Now she's going to talk about the balance of the harms. Okay, I need notice. I need a hearing. You're not being charged with the crime, not yet. You'll get a notice and hearing when those charges come down. But here's what they say. She possesses a property interest. No, she does not, in her position on the board. And again, with the reference to the historical pedigree of the Federal Reserve, which is a joke, and the special importance of the independence of the board, the due process clause guarantees that she gets oral at minimum, oral or written notice of the charges against her, an explanation of the employer's evidence, and an opportunity to present her side of the story before she's fired. And then all of that, of course, is shackling the president from the presidential prerogatives to take care. And critically, both the Supreme Court and D.C. Circuit say that hearings must take place prior to the discharge. Now, she didn't get notice. Just 30 minutes before Pulte posted about this, Trump went on and demanded that Governor Cook resign. Now, the government cannot post. That's not proper notice. Sounds like notice to me. You guys knew about it. For starters, neither Pulte's post nor the government's response states that the president was considering removing her for cause. And without that notice, she was entitled to it, and they can't remove her without the due process protections. Now, she didn't get an opportunity to be heard. And Trump has said multiple times she must resign. But in the final section, Abby Lowell for Lisa Cook is going to explain how damaging this is. And we're not seeing emotional damage in this one like we saw with the FBI agents when they were suing Trump for emotional damages. We now have reputational damages because they all came from Trump, not from the fact that she has fraudulent mortgages. So here's what Abby says. The government asserts that the unprecedented removal of a governor should be treated like a regular run-of-the-mill employment case. Not really. He's got for cause. There's been a bunch of other, kind of escalations of this. And he's the president. So he can fire key people under the executive branch because there's one executive at the top. To the contrary, this case is a genuinely extraordinary situation. Yeah. In which the circumstances surrounding an employee's discharge so far depart that irreparable injury might be found. What is the irreparable injury? She got fired from her job. She's not entitled to a government position forever. To start, preventing Governor Cook from discharging her duties is irreparable harm. And that point has been rebutted many times over by the Supreme Court, right? In most employment cases, there is a background presumption, he even explains it, that jobs are fungible, right? You can swap them out. Other people can do you're not like a special, it's not yours. And that the loss of a job can be remedied through back pay. But this presumption, right, the default standard, it doesn't apply to Lisa, a Senate-confirmed officer who has sworn an oath to ensure the stability of the financial system while she's committing mortgage fraud, allegedly. There is no remedy at law, whether back pay or something else, that can redress the harm that she will suffer if she can't be a public servant and carry out her obligations to the American people. Now, remember, Scott Dellinger sued Secretary Treasury Scott Bessent. Dellinger was the Hunter friend, apparently went to law school or something like that. And then he sued, said, you can't fire me. They said, yes, we can. And he's gone. The court in Dellinger explained that the wrongful removal of Dellinger would not be irreparable harm because he would remain out of office for a short period of time. That was probably during the injunctive phase. Not so here, saying that she's going to be replaced. Says, Trump even said, we've got some good people for this position. Even Stephen Moran might be somebody. He's already been submitted to the Senate. Yeah, because she's fired. Yeah, you got to fill it, obviously. So she's gone. Trump has to fill the position. So he's working on it right now. So then she's fired. And so they're saying this is going to be devastating for her. And they also say, by the way, the Dellinger case is non-precedential. Almost every court saying you can't rely on that. And in other cases, this court has reiterated that injury is irreparable when they're removed from congressionally important positions. In another case, from Judge Ali, of course. Yeah, in Harper versus Dissent. Now, the only decision to reach contrary conclusions are for officials who had no removal protections, who had no property rights. But here's where we go. Now, even if the loss of her position itself is not irreparable harm, it's not, the president's for-cause removal of Lisa inflicts irreparable, reputational, and stigmatic harm. Pathetic. In a related context, they said, well, the DC Circuit says if there is a stigma, then that can implicate critical liberty interests. Unlike Dellinger or any other principal officer, she has been targeted under auspices of alleged wrongdoing in the paper and a criminal referral from a executive agency. These allegations pose a serious risk of tarnishing her standing among economists who already think she's a joke, and the American public, and making it impossible to take advantage of other employment opportunities in the future. She's already been outed, man. You think that just keeping her in that, so I guess now it's like you have to keep her in that position because Trump damaged her, so she can't get a job somewhere else, so now you can't get rid of her. Indeed, there is a risk that the Federal Reserve could refuse to reinstate Governor Cook. The only clear way to clear the cloud over her name is to immediately reinstate her. And this is also extraordinary because she's been deprived of her guaranteed process. Yeah. Accordingly, the court has repeatedly held that she should have been heard. And if you allow Trump to get her out of this position, even temporarily, that would amount to a crack in the foundation of the Federal Reserve's near century of independence. And that is a bell that could not be unrung, even if she were ultimately reinstated. And so closing this out, she says, all of this weighs in favor. This is pretextual. We've had political independence for 111 years, and Trump is trying to get her out. Congress has the national interest at stake, and they spoke about this, and even public markets, they're talking about the stock market, have reflected and reiterated the desire for independence in the aftermath of the Trump decision. And the nation's leading economic periodicals all echoed their support for a mortgage fraudster. It was like 450 economists or something who all signed some stupid letter. And we know that people who sign letters like that generally, right? We've seen the 51 intelligence idiots who had no intelligence at all saying Russian hallmarks. Give me a break. So accordingly, the public interest supports preserving the stability that the Federal Reserve has established. And we want you to shove her back in power. Signed by Abby Lowell in a pretty tedious filing here from the Lisa Cook defense team. Now, Bill Pulte is asking a very serious question. Okay, why hasn't Jerome Powell come out and said that Lisa Cook's conduct is not representative of the Fed? Maybe because it is representative of the Fed, all filled with fraudsters. And this case is progressing forward. We see they also filed a joint status report. And in this joint status report, you can see they're not getting along here. Okay, the DOJ, Trump, of course, being sued by Lisa Cook, they submitted this to kind of flesh out what's coming next. They write, all right, we're writing this together. Now, we agree that Lisa Cook will file her reply. We just read it. And then the government will submit a supplement tomorrow, which we'll look at. Plaintiffs believe, Lisa Cook, that the court indicated that Lisa could file another reply. And if so, that's going to come back down on the 5th, Friday. Now, Trump does not concur in that interpretation of the transcript, okay? You should not get another response. Generally, what you have is a motion, a response. So Lisa Cook files the motion for a temporary restraining order. Government files a response to the motion. Then she files a reply. That's the end of the sandwich, okay? You're done, should be done. We get a little supplemental brief that was permitted, and then she's saying, can I have a surreply to respond again? Now they're battling over that. So they say, we don't think she's entitled to a third brief in support of her pending motion. She already got two. We're filing a supplemental because you asked us to, but she doesn't need another response to our supplemental. But beyond the question of further briefing, we do not agree on the appropriate next steps. Now, Lisa believes the court should grant a TRO to preserve the status quo and then move for cross motions on the merits. And they propose a schedule whereby motions would be filed September 9th and 15th. We have hearings very quickly. Now, in practice, an expedited summary judgment proceeding may not require much more time than the defendant's, Trump's, preliminary injunction preference. But Lisa believes that any discovery issues, if there is discovery, can be resolved expeditiously and would obviate the need for either party to invoke federal rules of civil procedure. And as the court noted, given the issues involved in this case, a decision on the merits would result in a complete record for speedy appellate review. And so here's what Trump says. We think that there could be 3 stages of briefings, but Lisa only wants 2. Trump says that given the parties and the court's engagement in the legal issues presented by the emergency relief, they say the court should treat Lisa's TRO as a motion for a preliminary injunction. Okay, it's not a temporary restraining order. It's a preliminary injunction. You want it to be permanent, so let's just do it. We don't need to do this twice. We don't need redundant briefing, and it's not going to require any additional briefing now. Now, defendants do not agree, Trump, that expedited summary judgment is even possible at this stage. Although the legal questions relevant to Cook's request for emergency relief will be briefed by September 4th coming up, the issues likely material to any summary judgment proceedings, which would resolve the case, right? You win, you lose, include factual questions. And so we need discovery. For example, whether Dr. Cook had actual notice of her potential for-cause termination. Like, did she get the Truth Social? Did somebody text her about it? Of course she got noticed. And the underlying facts giving rise to that termination. So we got to know. She says, I didn't get notice. I had no due process. Yeah, you did. You didn't? Well, come in here. Let's have a deposition and see what you have to say. And give us your cell phone records, because we know you got texted from that. Probably Jerome. He's like, oh, we're in big trouble. Any summary judgment motion would be premature at this time. And so accordingly, Trump says the court should treat her motion as a preliminary injunction, adjudicate that motion, and stay further proceedings pending any appeal. And we further request that you also adjudicate the other motion before the Federal Reserve's next meeting, right? The clock is ticking on this thing too. September 16th, coming up soon. So Abby Lowell signing that. And look at all these people, man. It's Abby Lowell, all right? And guess who else is on here? Norm Eisen, the Democracy Defenders Fund. It's like, man, these 2 peas in the pod representing a mortgage fraudster, representing Tishy Latish, representing Hunter Biden, Abby Lowell, all of them. And someone else, I think someone else who just got fired. Whatever her position was, she went and hired him too. So that's coming up soon. We had a great comment on our locals this morning. I think you may have seen it, but it's really relevant to what we're talking about here. Our friend TurboEncabulator is saying, I was looking into Lisa Cook, and look what we got here. I was watching a video about Lisa Cook and her Ann Arbor property, where she claimed primary residence on mortgage documents. So I looked up the county tax assessor record and found that she also claimed the principal residence exemption for this home, 2024, 2025. So she's not living there, but she's getting tax benefits. The worst part about it is, what is that principal residence exemption? What is it for? It's a property tax that goes to the schools and the school districts. So she cheated out the schools of $5,700 over 2 years by claiming this exemption. She's taking from the kids. Look at that right there. Looked it up. 25, 24, principal residence exemption is a percentage, 100%. Shout out to TurboEncabulator for digging that one up. Hopefully Bill Pulte is listening to the show today. Speaking of Bill Pulte, here is the man himself. He posted this when he was outside talking to the cameras. C-SPAN says that he is saying, if you're going to be in charge of the Federal Reserve, you better know how to fill out friggin' paperwork.
I heard you talked about a second criminal referral for her. Yeah. Why the second criminal referral since she's already been fired?
Because once we dug in more, we found more. And anytime we find more, whether it's on a criminal suspect or otherwise, we try to report it to people. So we reported it to the DOJ. She said that she had a second home, but then in her disclosures to the U.S. government, she called it an investment in rental property. Investments in rental properties are different than second homes. And back in that time frame, 2021, where she took out these 3 mortgages, you had different rates for these different types of classifications. So it's very concerning, and the DOJ will have to figure out what they do with that.
Do you think the president or the administration is going to name her replacement while this litigation is ongoing?
I have no clue. You'd have to ask the president that. My main focus is on getting rid of mortgage fraud and finding mortgage fraud no matter who commits it. If they commit it and we determine that it's within our purview to prosecute it, we will refer it over to the DOJ, and that's what I'm singularly focused on. So,
are there other government officials you're looking into?
I don't. We're looking at a lot of different things. We refer criminally people every day, contrary to what people say. We refer people who are Democrats, Republicans, it doesn't matter. But we're not going to be deterred from pursuing people. But the ones that we've made public or have been made public by other people are the only ones that we're prepared to talk about right now.
Tom Dempsey with News Nation. The attorneys for Ms. Cook are saying this is all just an effort to get interest rates lowered and that there was never cause to begin with for her to be fired. What do you say in response to that?
Well, Ms. Cook is the one who filled out the applications, not me and not anybody else that I know. So she needs to account for why did she take these two mortgages out. She took out a Michigan loan, and then 2 weeks later she goes and she takes out another loan for a property in Atlanta. She declares both of them as her primary residence. Then you go back 4 months from that, she took out another loan. We're now finding on a third property, saying that it was a second home when really she declared it as an investment property.
Convenient.
So, this really has nothing to do with the Fed. It has much to do with public officials. If you're going to be in charge of the Federal Reserve, damn, you better sure know how to fill out a mortgage application. And boy, it's awfully weird that she potentially saved a lot of money by making so-called clerical errors, which were not clerical errors.
Do you know if she's still getting paid by the Fed or how that's working while you guys bring this?
I don't know, but Jerome Powell, he's got to answer for why he's not coming out and saying this is bad. He's destroying the credibility to the Fed by not saying that mortgage fraud is bad. I mean, we have great career people. We have great people at Fannie Mae and Freddie Mac. We have great people at the Federal Housing Agency. Why would somebody who's Jerome Powell not come out and say, you know what, if Ms. Cook did this, she should resign? So it's becoming more and more concerning by the day. And I say that because, not only from a legal perspective with mortgages, but obviously the mortgage market is very dependent on the credibility of the Fed. And so it's concerning.
And she's also stealing from the youth of America. So Lisa Cook, she sounds shook. I think that they are realizing that the weight of the Supreme Court precedent is anchored against them. And we've seen that in the recent decisions that have been coming down from them saying Trump does have this power. A lot of these independent bodies are getting a reckoning, and now we're at the Federal Reserve knocking on their door. The final boss, level 10. Let's go. All right, so good stuff there. Now let's turn our attention to the Fifth Circuit because this is a good one too. All right, so let's just start at the top so I can show you the case caption, and then we'll get to it. Major decision out of the Fifth Circuit. It is probably going to be appealed, so it's not a final decision. It might go to the full panel and we'll get a different outcome. And if not a different outcome, we'll probably see this puppy go up to the Supreme Court of the United States. But this is a case of the illegal aliens, the Tren de Aragua gangbangers, who we've talked a lot about here, all suing, getting special privileges in America because they're better than everybody else, according to one particular political party here. And the decision came down from 3 judges. It was a 3-2 decision, and it came from Southwick, Oldham, and Ramirez. But the area we're going to focus on today is the dissent from Oldham, because he's going to give us a very clear delineation of what is going down in this case. He's going to explain the majority and then give us his take and a beautiful history lesson as well. Now, this case has actually already come back down from the Supreme Court. These Venezuelans, this is the majority, were detained by an immigration official. They said, you're a terrorist organization. They sued for a writ of habeas corpus, saying, we're going to go to El Salvador. Don't remove us. Trump issued a proclamation invoking the Alien Enemies Act. We know about that. Now, the petitioner's motion for a TRO to prevent their removal went up to the Supreme Court, and the court granted an injunction. And this is where we saw the Supreme Court act pathetic, and they're like, well, the district court judge in Texas, he didn't act with haste. He didn't act quickly enough, right? And then they came back and defended that judge. And so this case has been pretty messed up from the beginning. So Amy Coney Barrett and the rest of them are like, you're going to remove the illegals? No. And then they issued the injunction. They said, well, we're not going to set the standard here because they're pathetic. They said, why don't you, Fifth Circuit, go and analyze it? So now we're 3 judges. It'll probably go to the full panel, and whatever they decide, whatever the outcome is, probably going back up to the Supreme Court anyways. And SCOTUS could have just told us how to handle these things at the beginning, but we're doing this loop-de-doo, round and around we go. So their motion for a TRO went to the Supreme Court, where the court granted the injunction, said don't remove them, crying about it. The court then remanded the case to us and said, you guys do the work. Why don't you determine whether we can continue this injunction and prevent Trump from removing these people? And they're going to give us their little history lesson, okay? Well, what is the statute? They say there's not a lot of Supreme Court authority on 1798, and they're going to give us a little bit of a history lesson, but we're going to get some of that history lesson in the dissent, and so let's fast forward to it. Here you can see we jump about 50 pages, and now we are at the dissent. And it's going to give us a lot of the same stuff from the opposite end, which I think is the correct interpretation. Saying here from Judge Andrew Oldman, and this is a banger. For 227 years, every president of every political party has enjoyed the same broad powers to repel threats to our nation under the Alien Enemies Act. 227 years, every one. And from the dawn of our nation until President Trump took office a second time, courts have never second-guessed the president's invocation of that act. Not once. The reason is simple. Determining whether the AEA's preconditions are satisfied, whether Trump can use the law, whether there is a declared war or any invasion or predatory incursion that's being perpetrated, attempted, or threatened against the United States, it depends upon matters of political judgments for which judges have neither the technical competence nor the official responsibility. They don't get to do the president's job for the president, even if they want to, and even if Amy Coney Barrett's very upset about it. Time and time again, says this judge, the Supreme Court has instructed that the president's declaration of an invasion, an insurrection, or incursion is conclusive, final in italics, and completely beyond the second-guessing powers of unelected federal judges who have no political accountability at all. They just say, no, we want illegal aliens here forever, and they can do whatever they want in our country. What? You don't have the right to do that. The law needs to be enforced. The executive does the enforcement of the law. You don't get to undo the executive's enforcement of the law. That rule does not apply only to presidents. It also applies to governors, okay? In a famous case from the 1930s, the governor of Texas declared an insurrection because some oil barons in East Texas were pumping too much crude. Supreme Court addressed that. It seems patently absurd to call profit-maximizing business practices an insurrection, but that's irrelevant, okay? They called an insurrection. Supreme Court said that's fine, but that's irrelevant. The Supreme Court unanimously held, even in Texas, by virtue of his duty to cause the laws to be faithfully executed, the executive is appropriately vested with the discretion to determine whether an exigency requiring military aid for that purpose has arisen. And his decision to that effect, he writes, is conclusive because it's their job to make the decision. It's not the judge's job that the judge delegates to the executive and says, well, we'll allow you to do that. We like what you're doing there. For President Trump, however, the rules are different. Yeah, we've noticed that a lot. Thank you for saying that, Judge. Today, the majority holds that the President, Trump, is just an ordinary civil litigant. His declaration of a predatory incursion is not conclusive. It's just like his opinion, you know, and far from it. Rather, they say President Trump must plead sufficient facts, as he were like some run-of-the-mill plaintiff in a breach of contract case. What? To convince a federal judge that the president is entitled to relief? That contravenes over 200 years of legal precedent, says this judge. And it transmogrifies the least dangerous branch into robed crusaders who get to play act as multitudinous commanders in chief. I respectfully, but emphatically, dissent. Love it. Amazing. And shout out to our Calvin and Hobbes fans too. Transmogrification was a big theme in that one. And It's exactly right. Robed crusaders. They think that they're the president. I'm the president now. I'm Judge Gia Cobb. Okay. I respectfully but emphatically dissent. Now, there's a lot of brilliance here, but we'll fast forward through a lot of this because he gives us a beautiful and brilliant history lesson. By way of background, he says, let's talk about the AEA claims in this case, okay? Congress passed the Alien Enemies Act, which Trump is now invoking, when our young nation was in the midst of a national security crisis. The statute's historical background gives important meaning to this. As George Washington's second term drew to a close, relationships with France had soured. The French revolutionary government thought itself betrayed by the 1794 Jay Treaty, which the United States signed with France's mortal enemy, Great Britain. So France took revenge on us. But it was not official declaration of war style revenge. Instead, rather, France gave free rein to privateers or private armed ships authorized by their government to attack enemy shipping. These privateers made a lucrative business of raiding American ships on the open seas. Much of their activity bordered on unabashed piracy. And by the time John Adams took office, we were on the verge of war, okay? France and the US. 2 days prior to his inauguration, the Directory, the latest form of the French revolutionary government, had issued a decree saying we're going to violate our own agreement with you. But nevertheless, the president wanted to avoid a full-scale war, and so Adams acknowledged that France had treated the United States as an enemy and urged Congress to take adequate defense measures. And he assisted on negotiations. But negotiations were destined for disaster. The Directory had not only refused to receive the Americans, and the history goes on. Then we have the XYZ affair. The envoys were outraged. More delay. A week later, Bellamy returned. The envoys, and it goes on, right? Then 1 year after Adams' inauguration, lots of history. Okay, we're going to fast forward through a lot of it. But he gives us, I want to just pause to just explain, this is history of the AEA, right? This is why it was created, how it's been used. The nation prepared for war here. Here were some other measures taken. The news of the mistreatment of the American envoys lit the country on fire. The American people raged. The nation prepared for war. A Department of Navy was established. French going to get it. 12 armed vessels, 10 galleys, authorized the new Navy to seize certain French ships. The president was authorized to commission privateers. Armed merchantmen were allowed to repel the French. I mean, and we've been talking about doing that here. Like armed, Minutemen in America. See how that goes. A Marine Corps was established. The regular army augmented by an additional 12,000 men. A provisional army, 10,000 men, and many others, right? A lot of people talking about those things. That was kind of the founding of the country. Local militias and things like that. We had a lot more responsibility for our own security. Now, these measures launched that would become known as the Quasi-War. And the Alien Enemies Act was one way to fight back against France. The AEA traded on a familiar concept from the laws of nations, saying all members of a nation, when you're at war, become enemies of the member of the other nation. And things get pretty aggressive. Now, we're going to fast forward through a lot of the history. You get the point. But the act focused on invasions. Southerners were gripped with fear. They believed the French were going to invade the southern coast. Southerners were not alone. Others were fearing an invasion from the north. The Federalists championed the Alien Enemies Act. Unsurprisingly, Republicans were less thrilled. They said it's a little too vague. What are you going to do? You can just do whatever you want, and it's like broad power. But they lost the argument. The Republicans' fears did not stop the bill. Although they were able to temporarily delay it, they would soon regret that decision. Okay, they got political consequences for that because they needed the power to push back against the French. Now, Adams never invoked his authority under the AEA. He himself never thought that there was the least likelihood of France sending an army to invade the US. Yeah, that would have been a mistake. The English learned that. Now, eventually fears subsided and an invasion of the South was impossible. The fledgling American leadership under the Navy, under the leadership of Benjamin Stoddard, would soon retake control of the American coast. And with the coast secured, the news having reached the Americans that Horatio Nelson had destroyed the French fleet, peace drew closer. And then we got a new ambassador, And that's the history. So then we get to some new stuff. But new conflicts have since emerged, says this judge. One such conflict is the focus of today's dispute. The United States versus Tren de Aragua, a violent Venezuelan gang intimately intertwined with the nation of Venezuela, just like the French had their pirates, that has infiltrated the U.S. borders and wrought violence and destruction across our country. Been doing it for a long time. They even have senators representing them. Founded in the mid to late 2000s as a prison gang, TDA quickly rose to prominence as Venezuela's most powerful criminal enterprise. Although they first began its expansion by spreading across South America, they're proliferating into North America. And in infiltrating our country, they have taken advantage of an ongoing border crisis, citing the Washington Examiner and some other declarations from Selwyn Smith. Somebody said, yep, TDA's expansion is coming in large part from them exploiting the record mass migration from Venezuela. Yeah, our country's being flooded with their criminals. As I have recently noted, says this judge, Oldham, millions upon millions of illegal aliens have poured into our nation since 2021. Shout out to this judge. Unsurprisingly, it's true. The number of illegal Venezuelan aliens in the U.S. has skyrocketed. In fact, in fiscal 2020, Border Patrol had 4,500 encounters with illegal Venezuelans. The next year, that number saw an 11-fold increase. 11-fold increase. Thank you, Joe Biden, for invading our country, treasonous person. In fiscal year 2023, the number of encounters eclipsed 300,000. Okay, 4,500 to 300,000 we were being invaded. All in all, Venezuelan nationals are now the second most frequently encountered group of illegal aliens. And these numbers do not include the innumerable gotaways that all evaded law enforcement. And when TDA members enter our country, they conceal themselves by, quote, mixing with ordinary aliens, and they travel along migratory routes, and they keep a low profile before establishing themselves in a new region. And some of them enter migrant shelters to recruit new people. Police in New York City, for example, have bemoaned that their membership has proliferated and its members have blended into the city fabric. Now, the danger that this TDA gang poses to our nation, says this judge, is hard to overstate. TDA is renowned not only for its size, but also for its use of wanton violence. Quoting news articles, TDA members have been linked to homicides, kidnappings, all the horrific crimes, and violence and intimidation. Here's one notable example that you didn't hear any of the Democrat senators crying about. Shortly before Trump took office, TDA members took over an apartment complex in Aurora, Colorado. They kidnapped and tortured 2 innocent people. The innocent civilians were bound, pistol whipped, tortured for hours. The male victim was stabbed in the leg multiple times. Gang members ripped the female's fingernails out using pliers. In response, a Colorado state court granted the city an emergency order to temporarily close the apartment because this was an imminent threat to public safety and welfare. 19 individuals were eventually detained, and police obtained arrest warrants for 3 more. This is not an ordinary criminal incident, okay? It's a gang taking over buildings. And that is not all, this judge says. This apartment complex was one of 3 troubled complexes in Aurora that the owners have claimed were taken over by the gang. The city's efforts to shut down these complexes have appeared to have been unsuccessful. All that has happened is the city just pushed TDA further into other properties. And Aurora residents who live near the apartment complexes overtaken by these gangs have been desperate for someone to respond and address this growing crisis in our country. Now, these violent attacks have not been limited to Colorado or apartments. All across the nation they're happening. In San Antonio, Texas, for example, TDA repeated similar tactics and taken over an apartment complex. In Miami, Florida, a former Venezuelan police officer was abducted and murdered by TDA members. In North Carolina, another TDA member, an illegal Venezuelan alien, was arrested for a mass shooting in Chicago, Illinois, which I think they like now. They're like, we like more shootings. They're not going to stop. Mayor Brandon said, we're not going to stop them. In Cobb County, Georgia, and other TDA members was arrested. He kidnapped and shot 3 women in the head in an alley in Chicago. They love it there. Says here, and perhaps most infamously of all, in Athens, Georgia, we remember, a TDA member beat and strangled to death a nursing student named Laken Riley, who was out for a jog near the University of Georgia. And I don't remember Van Hollen doing press conferences with her family. As if all that violence and destruction were not bad enough. And I know Van Hollen went to go meet with technically MS-13 in El Salvador when he went to go hang out with Kilmar. Kilmar was MS-13, TDA. They're two gang invasionary forces. It's one and the same. Terrorists trying to invade and take over our country. As if all that violence and destruction weren't bad enough, TDA's hostilities have gone beyond purely civilian targets. In fact, an internal safety bulletin sent across Border Patrol recently warned that TDA members have been given a green light by the organization's leaders to fire on authorities. One 19-year-old Venezuelan migrant and apparent TDA member called Bernardo was recently accused of shooting two New York City police officers who confronted him. Another illegal Venezuelan alien and TDA member was recently charged for attempting to strangle a federal agent to death. None of them should be here. As a result, local authorities have lamented that TDA is a transnational gang unlike anything we've seen before. They are more dangerous, they're more violent, and they're more organized than MS-13 because that's where Kilmar was. The judge writes, this is not just some gang. It is deeply intertwined with the sovereign nation of Venezuela. TDA has infiltrated Venezuela's military and law enforcement, and it has taken even greater control over territories there. And now it's a hybrid criminal state, just like ours. Initially, the Biden administration sought to deal with the threats that they pose using criminal law. Even Biden designated them a transnational criminal organization. But the Trump administration said that's not sufficient. As a result, they exercised their authority to designate TDA a terrorist organization, not a criminal organization. And it sanctioned several high-ranking leaders of TDA, including a lieutenant and another operative. Many of them are committing homicide, extortion, bombings, terrorism. But still, this judge says, given the unique threat posed by a deadly gang committing acts of violence and destruction within our borders at the behest of a foreign sovereign, President Trump considered even these aggressive measures insufficient. So he decided to use the AEA. He issued a proclamation and they began arranging for their removals. So then these three TDA gangbangers, they filed a habeas petition. But they didn't sue only for them. Okay, if they want to sue for themselves and say, hey, I'm not an illegal alien or I'm not a TDA gang member, I have a right to be here, they can file their petition and make their case. But that's not what's happened. They sue when they want the entire country to stop deporting illegals. They also sued on behalf of a putative class, and they contested both the merits of their removals and the adequacy of the notice and procedure. Now here, the procedural history gets a little complicated, so I just highlight the basics, says this judge. They first filed their ex parte TRO, meaning they didn't notify the government. They just went to the court and said, we want a temporary restraining order. And this was apparently first purported to be filed by a voicemail, by leaving a voicemail with the district court. What? The district court then assured them that they would act expeditiously on the relief. After, of course, hearing from the government, because they have a say in this. The district court also assured the illegals and their lawyers that none of them would be removed pending the court's decision. Now, that should have assured an orderly resolution of the case, but it didn't. We remember this. This whole case was really pretty disgusting, and we were pretty grossed out by what the Supreme Court did. Let's see if he gets to it. Alas, it did not. At 12:48 on Good Friday, petitioners filed another emergency motion, and they demanded, these are these former ACLU lawyers and things, demanded an emergency status conference and an emergency relief issued that very day. What happened next is wild, and it's wild to see a judge using the word wild. It's great. Approximately 133 minutes after the plaintiffs filed their motion, 133 minutes, the gangbang lawyers sue. 133 minutes later, like a bad movie, and 90 minutes after the party-imposed deadline that they submitted, they filed a notice of appeal. Okay, so the lower level judge doesn't even have a say because they didn't like that judge. They informed the court that they are appealing the order that was denying their TRO. but the judge never denied anything, as well as for the constructive denials, right? So he didn't actually officially deny your motion, but he hasn't ordered anything yet. And so you say, since I need an answer right now, that's a constructive denial. Then they got a secondary motion as well. Now, our court denied relief. We said there's no appellate jurisdiction here. There's no final order. He didn't even order you anything. So they went to the Fifth Circuit Court of Appeals. And then they also leapfrogged. So then the Supreme Court, for its part, this went up to them, granted the entire putative class, all of the TDA gangbangers, temporary injunctive relief, grounded in the court's view from Amy Coney Barrett and the libs of the constitutional inadequacy of the original notice about these gangbanger removals. The Supreme Court also granted a writ, held the Fifth Circuit did have jurisdiction, vacated our judgment, and shoved it back down in our faces. On remand, they said, we have been instructed to address these two questions. Tell us about their habeas claims and what notice is due. Okay, the Supreme Court doesn't even want to say it. They're just like, you did a very bad thing. Well, how come? You didn't give notice. Well, what should notice be? Well, I don't know. You guys figure it out. But what we saw was bad. It's pathetic. The named petitioners are not entitled to an injunction, says this judge. They raise two challenges. They say there is no invasion and that TDA is not a nation or a government. But they fail on both accounts. On neither front can we countermand the president's assessment. As far as they challenge this, they say that they're not even members of TDA. That also fails. So the named plaintiffs are not going to win, and that's enough to affirm the lower level judge's denial of the injunction. But there's also another reason. They haven't even met the standards. He says for over 200 years, courts have recognized the AEA vests sweeping discretionary powers in the executive. And at least until President Trump took office, courts had never countermanded the president's determination of an invasion or other similar hostile activity. Never, but now they are. He says start with Ludke versus Watkins. That case says that political branches, not the courts, decide the proclamation standards. And then he says it fits with 200 years of Supreme Court precedent. And so he walks us through the history, and I think we get the point of it, but Ludke arose during World War II, and a bunch of presidential powers were invoked. Ludke controls this case. The president himself has the power and determined that there is a threat. Countermanding that determination means the courts would be assuming the functions of the political branches. That's not their job. And it also exceeds our technical competence, okay? As Justice Story wrote for the court nearly 200 years ago, in a case to which I will return to soon, the evidence upon which the president might decide that there's a danger might be of a nature not constituting strict technical proof. Yeah, decisions have uncertainty to them. That's why they should be held by the people who make the political decisions, because they're the ones who are politically accountable. Judges are not. They got permanent life tenure. We judges could spend 1,000 years studying constitutional theory, and we would still have zero ability to predict certain things. And the president ultimately has the power. And so he goes through a lot more Ludke stuff and the Militia Act and the Mott case. And it's like a brilliant decision, okay? There's just a lot here. He just keeps going and going, Ludke. And I think it's much more extensive than the majority decision. But if you want to read the rest of it, of course, you can grab it from the Fifth Circuit. He's now going into Mott. And see if we can get to a conclusion here anytime soon. But what we've seen, I think, is accurate and obviously the proper interpretation. If the judges say that they're in charge of all of this, then they're actually the president. And that's not how our structure works. So let's see, fast forwarding over here, and it just keeps going. And all right, so we get the point. So that happened. Now, talking about invoking AEA powers, President Trump says some drug dealing TDA narco terrorists are now permanently extinguished. He says earlier this morning on my orders, and this would be very curious. I wonder if we'll see these judges say, well, where was their due process? What happened to them? Earlier this morning on my orders, U.S. military forces conducted a kinetic strike against positively identified Tren de Aragua narco-terrorists in the Southcom area of responsibility. Oh, dang. TDA is a designated foreign terrorist organization operating under the control of Nicolas Maduro, responsible for mass murder, drug trafficking, sex trafficking, and acts of violence and terror across the United States and the Western Hemisphere. The strike occurred while the terrorists were at sea in international waters transporting illegal narcotics, heading to the United States to poison our citizens. The strike resulted in 11 terrorists killed in action. No U.S. forces were harmed in this strike. Please let this serve as notice to anybody, even thinking about bringing drugs into the United States of America. Beware. Thank you for your attention to this matter. And here's the video that was posted. You can see illegal Tren de Aragua gangbangers over here. Bunch of drugs in that boat making their way up the coast. With a close watchful eye from our military apparatus, saying, we don't want those drugs here, terrorists. Another angle right there. Until they're no longer in existence. Okay, so the boat has been now destroyed. So, Trump, and when I first saw this, man, I thought, oh my goodness, we're actually protecting our country in our own hemisphere? This is wild. We're using America's military to protect America? What the heck is going on here? We've been wondering where this has been for a long time because, of course, we bomb, a bunch of other people for unknown real reasons. But here, we've got hundreds of thousands of Americans dying, being poisoned by these drugs. And Biden let a lot of it in. And now we're stopping it. And we're happy to see some progress on that. But you're going to hear a lot of the lefties screeching about this. They want well, they weren't convicted of drug smuggling. They're terrorists and they're bringing them into our country. And so the president made that decision. And if you're unhappy with that, then Congress can, of course, impeach him. But they won't because it was the right call. The United States has long, says Rubio, established intelligence on drug boats, and we're now taking them out. Rubio posted this from the Department of State account.
The United States has long, for many, many years, established intelligence that allow us to interdict and stop drug boats. And we did that. And it doesn't work. Interdiction doesn't work because these drug cartels, what they do is they know they're going to lose, 2% of their cargo. They bake it into their economics. What will stop them is when you blow them up, when you get rid of them. So they were designated as what they are narco-terrorist organizations. So the same information and the same intelligence mechanisms with maybe a higher focus was used to determine that a drug boat was headed towards eventually the United States. And instead of interdicting it on the president's orders, he blew it up. And it'll happen again. Maybe it's happening right now. I don't know. But the point is, the president of the United States is going to wage war on narco-terrorist organizations. This one was operating in international waters, headed towards the United States to flood our country with poison. And under President Trump, those days are over.
Yep.
The United States.
We're happy to see it. So that is a nice development. Rubio saying we're going to continue to do it too. No more drugs coming in here. Vance was asked about it today. Here's what he said in response as well.
On the Venezuela vessel strike, what legal authority were you guys working under, and will there be an after report on the strike?
Well, I'm sure there's going to be an after report. I mean, the legal authority, and I want to talk about these kids, is that there are people who are bringing literal terrorists who are bringing deadly drugs into our country, and the President of the United States ran on a promise of stopping this poison from coming into our country. Another question?
And he's the president, so he's got the power under the Alien Enemies Act to do it. And Trump was also asked about this today during an Oval Office conversation where he was hosting the, I believe, Polish leadership. And here is what he had to say about this bombing.
On the boat, you had massive amounts of drugs. We have tapes of them speaking. It was massive amounts of drugs coming into our country to kill a lot of people. And everybody fully understands that. In fact, you see it. You see the bags of drugs all over the boat. And they were hit. Obviously, they won't be doing it again. And I think a lot of other people won't be doing it again when they watch that tape. They're going to say, let's not do this. We have to protect our country, and we're going to. Venezuela's been a very bad actor. They've been, as you know, they They've been sending millions of people into our country, many of them Tren de Aragua, some of the worst gangs, some of the worst people anywhere in the world in terms of gangs. And we had some in Washington, D.C. We took care of them very quickly, but they're out of here. They've gone. But Venezuela's been very bad, both in terms of drugs and sending some of the worst criminals anywhere in the world into our country. They emptied out, you don't know this, but they emptied out their prisons in Venezuela, and they emptied them out into the United States of America. And that's part of the problem we have. We're getting them out. We're getting them out rapidly, but it's caused a tremendous problem. And Pete and all of the people that are working very hard to rectify the stupidity of the Biden administration, allowing these people to pour into our country with open borders. We are paying a big price as a country for the incompetence of the Biden administration. But think of it. Opened up prisons, drug dealers, drug lords, everything coming out of Venezuela. They said, and we said, we're not going to put up with it anymore. So Venezuela has been one of the worst actors in the whole group, and we have a group of pretty bad actors.
And we have a smaller group today, thanks to the decision-making of the president. So it's nice to see our military protecting Americans. It's nice to see Judge Oldham obliterating the majority on this case. We think that the full panel may reverse it. Otherwise, it's going back up to the Supreme Court, and then they can tell us why they think the president doesn't have this power and settle it for us once and for all. And maybe they will, but we'll keep our eye on it. Big shout outs to Judge Oldham for that burner of a dissent. We appreciate him saying things that are true and calling out the other judges who can't recognize what's happening to their own countries. They live here too, and we should expect better. All right, my friends, what a beautiful stream it has been. Thank you for joining us today, and thanks for sending in some donos and some love and supporting the work that we do. And Donut and John, thank you for clipping for us. KB and Carrie B, thank you for clipping for us this morning. Here we go, baby. It's Wednesday. Happy Wednesday, my friends. Boss Bobcat. Man, he's knocking out some serious files right there. Good for him. We got this one from Chubby. Says, since it's the dissent that shreds, I'm assuming the majority was yet another BS activist lawfare ruling. The inaction of both Congress and SCOTUS on this judicial activism fiasco is becoming rage-enduring to me. I can't even describe in a family-friendly way how tired and fed up it is making me. Look at that stupid San Francisco judge. Ruled again that Trump violated the law and the Constitution when he ordered reserves into California, even though he was already overturned on that. Yeah, and that was Judge Breyer. And like, Judge Breyer is writing these little blog posts. It's hysterical. I think they're very happy with themselves there in California. It's like, what? Even the decision is like meritless. The decision was about Trump can't use military force for military purposes on American soil. It's like, duh. Everybody has already known that. Nobody's even argued over that. But Trump can still do these other things. You're like, how is that a giant victory for you people? They just like to say things that make them feel happy and good, even if it's delusional. Bruce Wayne, what's up, Bruce Wayne? Thank you, Bruce, for becoming a member, my man. At 61, Bruce Wayne, newest supporter in the house. Nice to have you here. Chubby, what's up? I asked Grok and Gemini, each where in the Constitution it says the president can't make mean tweets or truths, and also can't fire anyone nor do anything actually presidential, and neither of them could find it. I'm so shocked. I know. It's because it doesn't exist. They just make it up. They just said, well, but we don't like you, and so we're just going to change everything. Psychological projectionists. Dems say due process, but they mean duplicitous process. Yeah, basically, due process for them is basically whatever they want. It's like there was that one movie. What was that? Like Big Daddy with Adam Sandler. And remember that kid played that card game with him or something? And like no matter what happened, the kid won. He's like, I win. Well, why'd you win? He's like, I don't know. Why? Because I win. That's how the game works. That's the Democrats. They're like that kid in that movie. This old guy says, okay, but what about the irreparable harm, her violation of the law, and what that did to the Board of Governors? Huh? I know. It's like, what do you... Her paperwork has caused this whole problem. Like maybe her paperwork should have been in order, and then it wouldn't be an appearance of impropriety if she didn't lie on her mortgages. Thank you for that, this old guy. It is a bizarre thing. Object Class Keeter in the house says constitutional amendment. Any congressional representative or Senate confirmed when talking to the media or talking in official capacity outside the halls of Congress is by default under oath. And I don't know if the president should be included. Yeah, that'd be interesting, right? And we've talked about this, like, we had another friend on Locals who said that we should have we promise to tell the truth oath kind of a thing. Like you promise to tell the truth. If you don't tell the truth, then that's a violation, right? How do you hold your politicians more accountable? It's an interesting idea. Hey, what's up? Fletch in the house. Hey, thank you, Fletch Towel, joining us. Thank you, Fletch. Nice dono. Thank you for all you do, Robert. Thank you, Fletch. Thanks for being here. Thanks for supporting us with your love. We appreciate you. Couldn't do it without you. Thank you again. King of Biltong, what's up, King of Biltong? Craving a snack that's bold, authentic, and packed with protein? Question for you. Biltong boasts over 50% protein, B vitamins, creatine, iron, zinc, and more. Get yours at biltongusa.com and use code Robert for 10% off. Thank you, King of Biltong, for the delicious snacks. Doan, get ready to see Maduro in bracelets real soon. Yeah, and I think they got like a $50 million for him, right? If anybody has an eye like on Maduro and has a good plan, let me know. What's up, Doan? TDA is a reversal of the Mexican cartel Los Zetas, who are and were ex-MNP. TDA are bled-in gangsters who were still in the Venezuelan MNP. Yeah, that's interesting. And I've seen pictures of them. They're armed up. They're teched out. They got $15,000, night vision goggles and stuff like that. Like, what the heck? Where'd they get all that from? Severus, thank you, my man. 5 new membos coming in, courtesy of our friend Severus. Crawfish Creates, welcome. Bria Love, Clara J, Nocturnal, and J Mikey, all gifted membos. We'll see you in the after party coming up very soon. Doan, Maduro couldn't run TDA from Caracas. Well, I mean, who knows how much he actually is running? Like, is the gang kind of running things down there? I don't know. Doan, this old guy says, really amazing how quickly a TDA drug boat at full speed can be brought to a complete stop. Yeah. Aerial projectiles generally will do that to a boat. Good to see you, this old guy. Yeah, maybe they'll have second thoughts before they load up all their drugs and bring him here. Sino Bio Herrera. Thank you, Sino, for the dono. Appreciate you being here and for sending that in. Dark Road. No one writes their emotional principles better than a Republican. No one acts on their emotional principles better than a Democrat. Yeah, I think that's interesting because the Republicans, they do send a lot of letters, don't they? They do write a lot of letters. But the Democrats will actually just, like decapitate your entire political party. They do act on it, and they're hysterical. Duck Fat, what's up? Can't wait for the mainstream media to ask Trump how he could blow up drug-dealing terrorists with a missile. Trump responds, would you prefer an American citizenship in a coffee shop with a drone strike? Like Obama did? Yeah, from Duck Fat. They want all elite. They're like, no, they were just coming here to start a pharmacy in America. And they're providing the drugs that Americans don't want to provide. That's why they need to be here, because Americans won't do these jobs. All right, my friends, thank you so much for sending those in. Let's say hello to our friends on X. Then it's after party time. We'd love to see you come join us if you care to. Let's see. We got any comments over on X? And man, we are posting a lot. Have you noticed the increase of our shorts production? It's gone up dramatically. And now I can't find our live stream. I don't even know where it is. Are we even live right now on X? Looking, not finding it. All right, hopefully we are. All right, sorry, X, I can't find where you're at if you're over there. It's not showing up on my profile. All right, so shout out to our friends on X. Thanks for watching over there if you're watching over there. Now, we're wrapping it up on the day. It's after party time, baby. So if you'd like to come join us, become a member. Thanks for joining up on YouTube. You'll get a new link in just about 30 seconds. And we'll see you there. Locals, friends, hang tight. And of course, we'll see you in just a second. But my friends, it's been a beautiful stream. Thanks for joining us today. If you're looking for some Epstein stuff, a reminder, we did that this morning. So go check out that stream. A lot of kind of reaction after the press conference is over in that. And we'll see what you think about it. So It's been a beautiful stream. Thank you for being here. Big shout outs to our mods and meme smiths. Thank you so much for helping out around here. Donut Mind Me, John in the house, Carrie B, K Bean. We got Neuro D, Dog Digger, Janek. We've got our friends Elliot, Just Rhonda, and Jigum all modding the fort down for us. And we're grateful for you. And we want to see you back. Thank you for subscribing. Thank you for liking this video on the way out. And of course, come on back here tomorrow because we're going to be here and we need to see you in order to do it appropriately right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. We brought the heat with every chat and line. Together we exposed corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers shine in the light. Watching the watchers defending what's right. Watching the watchers stay